Well, good evening, everyone, and welcome back to AJ102, Introduction to Criminal Justice and Law Enforcement. And congratulations, if you're hearing my voice right now, we have made it to week 17. This basically is going to be our review of our Chapter Exam 3 study guide. And we're doing this during week 17 because the following week, week 18, is going to be your finals week where you're going to need to take your final exam and clean up any other things that need to be done before the end of the semester. So what I want to point out are a couple of things to help you on your final exam. The first thing will be what we're going to be doing tonight is basically an overview of the Bill of Rights, because we started early on 17 or 18 weeks ago with the Bill of Rights, and we're going to end up with the Bill of Rights because of its significant impact on policing, not just public safety, but the entire criminal justice system. So we'll take a quick look at that. Don't forget, in every week's content folder, we have a non-narrated, if you will, PowerPoint where you can go through at your leisure and flip through the slides to get your information, or you can listen to the narrated version where I speak, and I know it's super exciting, where you get to hear my voice and I walk you through the slides with a couple of additional comments and what have you. The last piece, and probably the most important piece for the final, is your Chapter Exam 3 study guide, which is posted on Blackboard. There's a link on the left side of your home page on Blackboard where you can click on that. You can find the study guide and you can download that, and you can use that to reference where I am kind of guiding you as far as some of the questions are concerned. Now, your final chapter exam will encompass chapters 11, 12, 13, and 14. So you have 4 chapters, and you never know, you might get a surprise with something from the Bill of Rights. So while this might be a review for some of you, it's always good to kind of refresh. So let's go through this, and then we'll jump right into the rest of our discussion tonight. So the Americans declared their independence from Great Britain in 1776, and in 1787 they adopted the United States Constitution. Now, this Constitution basically told them how their new government was going to work. However, some states still thought that the Constitution wasn't specific enough and didn't say enough about the rights of the people. So in 1791, Congress added the first 10 amendments to the Constitution, and these first 10 amendments are commonly referred to as the Bill of Rights, and I'm going to throw in the 14th because it is so important. Now, these are individual rights that the government can't take away, and while we don't apply every one of these each and every day in policing, you will quickly see, or you have learned hopefully, that some are very, very important to law enforcement and the job that we do each and every day. And again, while all of these 10 amendments and the 14th Amendment are very important, there are some that are going to stick out that really have a higher level of application when it comes to the day-to-day things that a police officer might do. So here we go, the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. Well, what does all of that mean? So I've kind of put it into just a couple of bullets on this slide, and also you'll notice at the top you'll see a little YouTube video link, and if you want more information you can click on that. It'll take you to YouTube and you can watch a 4 or 5 minute video on each one of these. But back to the First Amendment: freedom of speech, freedom of religion, freedom of the press, the right to peaceably assemble, and the right to petition the government for redress. The Second Amendment: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, we're not going to have a lesson on the Second Amendment, and while the Second Amendment does talk about the right to keep and bear arms, you must understand that there are different laws in different states, because the states can enact these different laws, and where you might be able to carry a firearm in public in one state, you will not be allowed to carry it in a different state. So open carry is a big challenge with law enforcement right now. So this really kind of goes back to the home is your castle, and you have the right to defend your castle type concept. But again, the right to keep and bear arms and gun ownership issues under the Second Amendment. The Third Amendment, this amendment guards against the forced quartering of troops, because in the years before the American Revolution, British officials forced the colonists to basically house and feed, or what they called quarter, British troops. So keep reading. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. The Fourth Amendment, one of the biggies, not like the other ones aren't, but this one is big. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And we'll stop there for a second. It doesn't say against searches and seizures. It says unreasonable searches and seizures, and hopefully you've learned what unreasonable means. Continuing, shall not be violated, and no warrant shall be issued, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So to kind of wrap it up, it forbids unreasonable search and seizure in a couple of cases that are applicable to this term, called the exclusionary rule, where things might be excluded. Hint, hint, Weeks versus United States and Mapp versus Ohio. So those are some issues relating to the Fourth Amendment. The Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime, excuse me, unless on a presentment or indictment of a grand jury. So stop for a second. Not all counties file their cases through the grand jury. Some do, some don't. There's an exception to the rule here that came about, to where you can take a felony case to the district attorney and they can file those cases, and a misdemeanor case too, but you can file your criminal cases through the district attorney's office without having to always use the grand jury, as it says here in the Fifth Amendment. So just kind of keep that in mind. Except in cases arising in land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, tried twice for the same crime. But there is an exception to that as well, and we don't have time to get into that, but nor shall be compelled in any criminal case to be a witness against himself. You don't have to testify against yourself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. This kind of focuses it down. No double jeopardy, being tried twice. The privilege against self-incrimination and due process. The Sixth Amendment. In all, and this is another big one too, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, jurisdiction, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. What am I being charged with? To be confronted with witnesses against him. You have the right to confront your accusers and cross-examine witnesses, to have compulsory process for obtaining a witness in your favor, subpoena power of the court to bring people in on your behalf, and to have the assistance of counsel for defense. So this amendment, in essence, kind of establishes requirements for criminal trials: a speedy public trial, informed of the nature and cause, confront and cross-examine witnesses, the subpoena power of the court, and of course legal counsel. The Seventh Amendment really lays out the rules of common law. The Eighth Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. So the excessive bail and fines, we kind of get that, but the cruel and unusual punishment part, what does that mean? Well, it really kind of gets down into things like maybe the death penalty and whether that's cruel and unusual. And that's kind of, some focus on the Eighth Amendment. The Ninth Amendment ensures that individual rights that are not enumerated in the Constitution are secure, and basically means that these rights should not be automatically infringed upon because they're omitted from the Constitution. So just because they're not there written down or numbered in there doesn't mean we just toss them aside. And that's the essence of the Ninth Amendment. The 10th Amendment, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are preserved to the states respectively or to the people, and we can make laws. The 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are, not could be, or should be, or would be, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges excuse me, or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection under the law. Go to the right of the slide, go down to the bottom. The title bullet says equal protection. Read the next line. All people are created equal. And that should pretty much sum that one up for you. So now that we've kind of got the first 10 amendments down and we threw in the 14th Amendment, let's kind of get into the study guide a little bit, and I'll kind of give you some ideas on where you may want to kind of focus your attention. And hopefully the study guide does really help you. So we're going to be starting with Chapter 11 and issues of police conduct. And there's one thing I just want to kind of say as we start to read this chapter, and again, this is just we're just going to brush over some things, but it says here, and Calvin Coolidge wrote this or said this: no one is compelled to choose the profession of a police officer. Meaning, no one's going to force you to do this kind of job. No one forces people to do that kind of job. But having chosen it, meaning now that you've accepted that and you've chosen this, everyone is obligated to perform its duties and live up to the high standards of its requirements. That's super, super impressive. And it very is true. I mean, no one's compelling you to get into this job. You're doing it for whatever reason you're doing it, and hopefully it's to help people in need and protect those that need protecting and defend those that need defending and arrest criminals and do all that other stuff. But if you're going to do it, and I really kind of like this, do it to the fullest extent. Understand that you have that bar is set very high. And that's kind of the essence of the conversation as we go through some of the questions and what have you. So number one, know what reflects police perspectives on vehicle pursuits. So how do police kind of view pursuits? And we're going to jump around a little bit in the textbook, so I'm sorry about that. And there's a lot of things to read in here that are really, really important. And there's a whole section on discretion, which really is one of the most important pieces of this entire chapter. But when we talk about car chases and pursuits as well, how do the police view pursuits? I mean, do they view them to be dangerous, or do we understand that we have to control them? Do we know that when we get in a car chase that the people involved, both the suspects and the police officers, there's a rush of adrenaline and excitement? Or is there some type of other viewpoint in there? And I would venture to say that some of the things I just talked about are pretty applicable to number one. Number two, know what the case of County of Sacramento versus Lewis set the standard for. And there's an interesting phrase out there that maybe some of you have heard and maybe you haven't. And it's the term called, well, what do you think it is? It's the term called liability. And, while there are a couple of different definitions here and there, liability is a big thing, especially when you're talking about being like a staff member or a chief or something. And liability is kind of a legal obligation that is incurred for an injury suffered or complained about that results from failure to conduct a specific task within a standard. So an example would be like you have this general orders, you have a set of rules and guidelines, and when you deviate from those rules and guidelines, if you will, then you can open yourself up to this, what they call this legal obligation. And this case that we're talking about, the County of Sacramento versus Lewis, kind of set the standard for just that. So hopefully that kind of helps you out on that. Know some common less lethal force alternatives. Well, when there are, everybody kind of understands what lethal force might be, but there are other things that we can use that are on maybe that use of force continuum in your book that you can look at that talk about different types of maybe weapons or things that we can use that are what they call less lethal. Where we don't have to automatically result to a firearm. So what are some of those less lethal force alternatives? Now, I won't give them all to you, but one could be like a taser. And I say taser because everybody thinks that's cool. But so that could be one less lethal force alternative. Number 4, what are, or know what 3 factors are built into most police policies regarding police pursuits. Well, there are some things that we have to kind of think about. And I'll try to give you examples of this without giving you the answer, because that's not really what I'm here for. I'm here to kind of talk about those things that you need to think about. So the factors that are built into pursuit policies in police departments are factors that may impact the way that you drive. So an example, one of them could be, what if it's raining outside? Would that impact maybe a car chase, and maybe you wouldn't want to get in that car chase? Does that make sense? And I hope it does. So that's just one, but that's an example of one that could really, that are put in policies for officers to think about when they get into these kinds of things. Number 5, know what most discretionary option is that a police officer possesses. Well, think about that. Discretion is big in law enforcement, and discretion by definition is the freedom of a person, okay, or an agency to choose to act or not. And the question kind of comes down to whether or not that discretion is positive or negative. But what do you think the most impactful, okay, if you will, that a police officer has? I mean, do we have the ability to take away somebody's freedom? Well, yeah, we do, and that's pretty impactful. So without giving you the answer, you just have to kind of like, think about that. So we'll kind of move on a little bit. Know the definition of discrimination. Well, that's in your, it's in the slides, and it's also in the textbook. Know what racial profiling is. That's in there as well. Know what constitutes excessive force. So as we start to talk about different things in this particular chapter, you're going to see the use of force continuum in there. You're going to see use of force, and force is an action taken to compel a person to comply with your request. So if you're an officer. So with that being said, we know what force is. What would excessive force be? So kind of think about that one for a minute. Number 9, know what the 4 factors are that contribute to an officer's conditioned hesitation. These are also listed in your textbook, and a lot of things kind of might make an officer like hesitate to not do something, and they call this conditioned hesitation. And one example that I can kind of give you without giving away the entire answer or something like that, would be um, the example of maybe how you shoot in the range. So every week you go to the range, or every month you go to the range and you shoot in the range, and you always stand in the same place, and you always shoot at the same distance, and it's very slow, it's very deliberate, you're not moving around, and then when you're done, after you shoot, you pick up your brass off the ground, because you don't want to leave the brass on the ground, because the sergeant gets mad because you leave the brass on the ground. After a while, that's how you've trained so much. If you were to get it is possible, if you were to get in a shooting scenario, that you revert to your training, and if that's your training, there might be an issue there. So there are some situations that are listed in your book that talk about factors that have been shown to contribute to an officer's conditioned hesitation. And that's kind of what we're looking for that particular question. Then know the definition of liability. Well, I kind of read that to you a few minutes ago, so you should be pretty on top of that. So now we're going to move on to the next chapter. We're going to go to chapter 12, and we're going to talk about becoming a law enforcement professional and how do you really do that. And yeah, there you go. So chapter 12. So number 1, know the steps, or the step in the hiring process that is done first. Well, kind of think about that. I mean, the very first thing that you do, what would that really be? And, think of it in a sense of, you would have to apply. So that, in essence, that could be the first step of actually getting into the process. Number 2, know what is required for a person to become a police officer. And there's 3 basic things that are required for a candidate to become a police officer, and they're on the slides in the textbook. Number 3, know why there might be a lack of qualified recruits. Well, how come? Why are we having a problem recruiting in there? And it could be a couple of different things, and I won't give them all to you. But again, so it could be maybe we have negative media publicity, and because of that, people don't want to get into law enforcement. So that could be one. Know what the written exam tests for. Now, you have to think about this one a little bit. Most people think the written exam is going to be like scenarios. And, what would I do in an armed robbery or something? Well, you're not trained yet, so you don't really know. And because of that, you have to kind of think of, well, what are they looking for? And in essence, some of the things that they're looking for, they wouldn't be looking for street smarts because you're not street smart yet. They're not going to be looking for your knowledge of policy because you don't know the policies yet. So it would have to be something else. Something a little more low level, like maybe reading, writing, a little bit of math, reading comprehension, spelling, things like that. And that's typically what the written exams are basically for. Number 6, know what a polygraph is used for. And that's in your book as well. So you'll be able to figure out what a polygraph is used for. 6, let's see, number 5, I missed that one. Know what the oral interview evaluates. Well, again, kind of like the written, you have to look at the whole thing there. Is it going to be used to evaluate like technical knowledge, like your knowledge of tactics? We don't know tactics yet. So think about that question. What would the oral interview be used to kind of evaluate? So I gave you something that it wouldn't be used for, so you can kind of think of the other ones, and they're in the textbook as well. Know whether women are involved in less use of force than men. Well, statistically speaking, women tend to be less involved in use of force than men. So sorry, guys. Number 8, know the critical physical tasks required for police applicants. And these are things that you might have to do in the field that they want to make sure you can do during the testing process. So, you got to think about it. So when you do like that, why do you think they have the physical agility test? So they have the written test that tests for some things. They have the oral interview test that they're looking for certain things. And then the physical aspect, they're looking for certain things. So when they're asking what are those critical tasks required of law enforcement for the testing part, it's going to be those physical things versus those other things, if that makes any sense. Number 9, know the term or know what the term hostile environment harassment means. Well, that's in your book, so I'll have you look it up, and it's also on the PowerPoints, I believe. But understand that, you know, any unwelcome sexual behavior, jokes, cartoons, you know, things like that can really result in a hostile work environment type situation, and you really don't want to find yourself in that situation. And the last one is know what the Civil Rights Act is and what it protects, and that one's pretty self-explanatory, and I don't think I'll have a hard time finding that one. Okay, so that kind of wraps up that one. Now we're going to move on to chapter 13, and chapter 13 is going to cover the U.S. court system, and, you know, kind of not the corrections part, but the actual court system, the overview of the court system, and, you know, you'll see some of the terms that if you've done your terminology quizzes, you'll kind of start to understand some of those things as well. So the first one, know what the preliminary hearing is used for. So I think we all know what a you know, what a trial is. We've seen it on TV, and we understand what a court trial kind of looks like from that. But there are things that happen before the actual trial starts, and a preliminary hearing is kind of a time when the judge determines whether there's probable cause for believing that an offense has been committed and that that person that's being accused committed it. And, you know, sometimes they call it like a little mini hearing, a little mini trial, but it really does seek to establish probable cause. And it also, that preliminary hearing seeks to establish probable cause to prevent people from being indiscriminately brought to court, meaning like just not everybody ends up coming to court. There needs to be, you know, and having this big trial. So there needs to be this little small trial, if you will, to find out whether or not there's enough to hold somebody over for the next step. Know what the term adversarial system means, and that's in your textbook as well, because our court system is adversarial in nature. And I'll let you kind of look up the rest on what that means. But our whole criminal justice system basically is built on the adversarial type system, and I think you'll be able to figure out the rest of it from there. Let's see. Number 3, know what the main focus of a reentry court is. So, you know, what is really the main focus of that? And inside you, again, remember I told you there are different courts. There's the state court system and the federal court system, and then there's juvenile courts and the Supreme Court and the appellate court, and, you know, then there's specialty courts. There's tribal courts, community courts, problem-solving courts, and then there's like smaller ones that are more that are kind of community-based, like drug courts and domestic violence courts, and then they have things like reentry courts. And you're starting to see more of this reentry support team concept in policing right now, because really part of this is to basically serve or service parolees before they're released from incarceration by working with correctional staff to kind of get these folks ready to move out into society. And they'll work with all types of different entities in order to do this. So that's kind of the essence of like reentry. Very, very valuable programs, by the way. Number 4, know what the term petition means. Well, you can look this up in the book, but in adult court, we have what we call a criminal complaint or a filing. And in juvenile court, you'll have something else. Number 5, know the main players in the judicial process. Well, the main players, I mean, you know, we talked about that are criminal justice system is adversary, and it requires the accuser to prove beyond a reasonable doubt to a judge and jury that the accused person is guilty of a specific crime. And in all this adversarial system are people like the defendant and like the prosecutor and the defense attorney and the judges, and those are key people that are in there. So use that to kind of help focus you in a little bit like that. Know the definition of plea bargaining. Well, what is that? And just by its mere meaning, plea means to admit to a certain degree, if you will, that you're going to go ahead and take a plea. Bargaining means to bargain. So kind of put those together, and that should kind of help you out. Know what a bench trial is? Well, we know what a jury trial is. A jury trial is a trial with a jury, and the jury decides based on the evidence and testimony and everything else whether or not the person is going to be guilty or not. But there's another type of trial that's not a jury trial. Number 8, know what cross-examination is used for. And that one might be a little bit tricky. We kind of know, I think we know what cross-examination is for. Or maybe not what it's for, but why we use it. So when the prosecutor is asking their witness or their victim a certain question or whatever, when they're done asking that person questions, the defense can come in and cross-examine that person. And there is a reason that they're going to come in and they're going to cross-examine someone. Now, typically, a lot of times, it's to gain information and what have you, but usually the defense is going to try to kind of discredit the prosecution's witnesses through things like cross-examination and vice versa. Know what a hung jury means? I'm going to let you look that one up. It doesn't mean that the jury hung itself. It means that something else. And number 10, know if it's important that a police officer be familiar with the criminal justice process. Yes. So there. Chapter 14, and the last one, we're going to talk a little bit about the correction system and how that kind of fits into everything else and the purpose of corrections and what have you. So hopefully what I'm doing right now has kind of helped you out a little bit, and you're getting a little bit of decent information on where we're going to kind of focus. So the first one, the question we're looking at is the definition of incapacitation. So don't get it confused with incarceration, okay, because it's a little bit different. So, incarcerating somebody means to put them in jail. Well, to incapacitate them is a little bit more definitive and a little bit on a higher scale, kind of making it impossible for, an offender to commit any further offenses because they're basically incapacitated. And that really was one of the earliest forms of punishment, or banishment way back when, was to, put people to death and all these big harsh punishments, because the thought was, hey, you know what, we'll just make it to where they can't do this anymore. So that's the essence of incapacitation. Know what response to crime is proactive and focuses on the future needs of offenders as well as the needs of the community. Well, when you start to read some of the definitions, and this is definitely where you wanted to start to look at some of your definitions, you're going to see some words like rehabilitation and recidivism and restitution and deterrence, and all of those are important things for you to kind of read. But the response to crime that's proactive and focuses on future needs of offenders, as well as the needs of community, I'll let you kind of figure that one out. And if not, then I'll help you out. But think about it, and we'll kind of go from there. The next one, rehabilitation. So know the definition of rehabilitation. That's in your textbook and on the slides as well. Know 4 alternatives to incarceration. So basically meaning instead of putting them in like a correctional facility, what are some things that we could do to where they don't have to go there? And I'll give you one example. Could be house arrest, meaning that you're supposed to be at home during certain times and blah, blah, blah. So there could be some other ones that go along with that. That would be one example of an alternative to incarceration. Know the definition of deterrence, that's in your book. Know the goal of restitution. Well, if you know the definition of restitution, you'll know the goal of restitution, and you know, I think that'll help you kind of clear that up. So I don't think you're going to have too much problem with that. Now, restitution, keep in mind, is to make sure that you are responsible through whatever means to repair, fix, replace, pay for something that you may have damaged, stolen, or what have you. So hopefully that kind of gives you some direction on that. Know the primary goal of correctional institutions. And so what is it? Why do we build all these jails and whatever? You know, the primary goal of correctional institution. Is it to punish offenders or even the score or teach people a lesson, or is it maybe to protect society? So know what that is. Let's see, number 8, know the primary focus of juvenile corrections. And you know, it's always been and it will always be rehabilitation. And then there you go. Know the difference between jail and prison. I'll let you look that one up. That's in your book and on the slides as well. Know the difference between probation and parole. Those are in there as well. And just keep in mind, you know, once you've got these, you'll be able to figure them out. Know what incarceration means. So what's it mean to incarcerate someone? And then finally, know what this word lex talionis means. And way back when, if you can remember that far, because we're already in week 17, but if you can go back to chapter 1, you will have heard that word before, or you will have seen that word before, as it relates to early methods of punishment. So primitive and kind of ancient law, if you will. And this goes all the way back to the Hammurabic Code, if you will. And that Hammurabic Code, or the Code of Hammurabi, whichever way you want to say it, basically there was a legal principle that came out of that. And that's the definition of lex talionis. So with that being said, that's kind of the overview of the chapters. I hope that was helpful to you and you're able to utilize whatever means you need, including the study guide and all the other things that I've given you to benefit you when it comes to taking your final chapter exam. I'd like to thank you all for your participation this past semester. I really hope that you learned something. I hope that you continue to pursue your law enforcement or public safety career. And remember, cops are better than firefighters. But on a more serious note, I hope to have you in another online class or perhaps even a face-to-face class. So please feel free to come up to me and introduce yourself as one of my online students. With that being said, also in either content folder week 18 or 17, I also have a couple of final thoughts that I'd like you to listen to. I think you will enjoy them. I hope they are inspirational in you pursuing the career of somebody in the public safety field. So until we talk again, that'll be it for tonight.